Oh, hey, everybody. It's me, AV. Welcome back to my YouTube channel where we talk about all things law, true crime, a little bit of debauchery. Just a bit, just a smidge. We're back. It's been a little bit. Shout out to everybody in chat right now. If you're just catching us, hit the like button, please. There's a new feature. Had to fix the settings. I heard myself. I was like, all right, that's that. We can't do that. We can't do that. Not while streaming. It's good to see everybody. Today we are talking about one Fani T. Willis. Okay. This morning, the Georgia Supreme Court finally made a decision on whether or not she's going to be involved in the Trump interference RICO case. Remember, she bought this case. She bought this case and she was very adamant that RICO is not only happening with the current sitting president, but also happened with YSL. So we're going to take a look at that official order. The decision came out this morning. One, Steve Sadow, the counsel for President Trump, released a statement. And then I have pulled the full decision for you guys so we can take a look. But for those that are just coming in, hit the like button and let me catch you up on all of the tea. I got lemonade for this one, because it's very interesting. Now, before I get started, if you don't know about Fani, Fani is the district attorney in Fulton County, Georgia. Fulton County, that county is home to one Atlanta. All right. I lived in Atlanta last year, and that's why this case hits home for me. Because why? My taxpayer dollars were going to some foolery happening in those courthouses. So I had a particular interest following this one. Last February, 2024, so not this past February, but in 2024 in February, there was a hearing regarding this case. At the time, Donald Trump was not in office. He is now. So that's a little bit different compared to what we saw last year. Now, Ashley Merchant, sister to this channel, one of the most favorite interviews that I've done on this channel was with Ashley Merchant. And we actually had a very enlightening discussion about RICO and how it is very broad in the state of Georgia, because we all wonder, all of us live in different states here in the United States. And we're like, how come you don't see RICO over here? How come you don't see RICO over there? We were looking for RICO in a YSL case for 172 days, just could not find RICO. Didn't know where it was. Now, this is a pattern with this particular district attorney, and we did think that that case was a little bit outrageous. If you don't remember, here's who was charged, or at least alleged to be a part of this RICO. So we have the former president, or actually now current president, and if there's one thing that Fani Willis was able to do is get this mugshot. She got this mugshot. This is President Trump for his booking photo at the Fulton County Jail in August of 2023 in Atlanta, right? So she was able to get this picture of him. Look at Rudy Giuliani. He was one of the people charged as well. These are all of the mugshots. Wanted to show this to y'all so you remember. You have, at the time when they wrote this article, he was former president, but he is now a sitting president. And he had 13 charges, including racketeering, soliciting a public official to violate their oath of office, and making false statements. He pled not guilty, and his connection in the original indictment was that he was not guilty of the crimes that Fani was saying that he was guilty of. What does that include? Trying to steal the Georgia election when Biden was in office, okay? They were looking at the votes in Georgia. There were some phone calls that were made by President Trump, and he was talking to these officials to see what was going on, all right? Among other things, it accuses him of planning alongside allies of misleading the public about the election in speeches, lying to elected officials in key states to get them back, to push back and overturn the election in Georgia. That is what Fani was alleging that he did. You had Rudy Giuliani, who was a former Trump attorney, also pled not guilty, but was involved in this RICO conspiracy. John Eastman, another former Trump attorney, nine charges for him. He also pled not guilty. This woman, Sidney Powell, she was a former Trump attorney, 7 charges involved in this RICO case. Kenneth Chesebro, former Trump attorney. So this is basically a lot of Trump attorneys being accused of this, right? You have Jenna Ellis, former Trump attorney, pled not guilty, 2 charges with her. Ray Smith, former Trump 2020 campaign attorney in Georgia, 12 charges, pled not guilty. Mark Meadows, former White House chief of staff, 2 charges, pled not guilty. Jeffrey Clark, okay, former acting assistant attorney general at the DOJ. Fani was coming for everybody, not guilty. Michael Roman, this gentleman, he was a senior Trump campaign staffer. This was Ashley Merchant's client. And Ashley was so important to this case because she is the one that literally shed light on it, got the public attention on it. That's how we found out about the affair with one Nathan Wade. We found out because Ashley Merchant was able to dig this information up. And I'll give you guys some more context on that once we get to some of the updates when it comes to Nathan Wade. So you have this Trump staffer that Ashley represented. You have Misty Hampton. Misty was a former Coffee County, Georgia election supervisor, 7 charges, pled not guilty. And then local operators and Trump supporters. Robert Chile, definitely remember that name, trial attorney in Georgia, 10 charges against him, pled not guilty. Scott Hall, Atlanta-based Trump supporter, 7 charges, pled not guilty. Stephen Lee, he looks like he's a pastor. Is that a pastor? That's a pastor. Stephen Lee is a pastor and a Trump supporter, 5 charges, pled not guilty. Harrison Floyd, we knew about this one, former leader of Black Voters for Trump, 3 charges, pled not guilty. And then Trayvon Cootie, oh my God, Travion, she has the most sinister look in her mugshot. Look at this, chat. I know she's very active on Twitter last year when this was all coming out, but her role is she was a Trump supporter and former publicist for celebrities like Kanye West. Well, 3 charges against her, pled not guilty. False electors, David Schaefer. He was a false elector and former chair of the state's Republican Party. 8 charges against him, not guilty. Sean Still, false elector and Georgia state senator, pled not guilty. Kathy Latham, also an interesting mugshot, false elector and former head of the Coffee County Republicans, pled not guilty, 11 charges against her. So these are all of the people that Fani originally came after, and they put Donald Trump at the beginning saying that he was the kingpin behind all of this, okay? So where does that lead us today? These RICO charges were going to go to trial, right? And there was a hearing last February. And that's when Ashley Merchant, amongst other people, found out that around the time that they were going to bring these charges against the president, that Nathan Wade and Fani Willis had an inappropriate relationship. They were working together, blah, blah, blah. Now, here's the thing, and a lot of people judge Fani for this. I'm guilty of that. Nathan Wade was married, and his wife has cancer. Okay, she's at home with cancer while this affair was going on. They have kids together. Nathan Wade admitted to the relationship, and Fani Willis admitted to the relationship. Now, throughout 2024 and 2025, we have seen they both deny that the relationship has continued beyond that point and that they are friends, but we have seen multiple instances of pictures of these two together. I don't know as of today, but I think the last photo I saw was in an airport of the two of these guys in May. So it appears that they're still talking. I don't know if it's pillow talking or if you know what's happening here, but we have seen some photographs of these two people. Okay, so they're saying that there's no relationship. Kind of looks like there is. I'm just saying. It looks like there is. So originally you had this indictment, 19 defendants. The trial was put on hold because the public found out about this inappropriate relationship. And then what did Steve Sadow do, who's Trump's lawyer? He filed an appeal and tried to get her kicked off of the case, right? The Georgia Court of Appeals back in December, it was right after the YSL trial had just wrapped up. Like Yak Gotti and Shannon just wrapped up their case, right? Like 2-3 weeks later, the Georgia Court of Appeals came out with their decision saying, hey, Fani's coming off. What did Fani do? She came back and she's like, well, we're going to raise it to the Supreme Court. I'm staying on. You have no basis to kick me off, right? So even though the Court of Appeals, they looked at everything, they're like, Fani, we're not siding with you here. We don't see, like, we don't agree with your legal rationale about why you should stay on. It does stink a little bit. It looks like there is what did they say? It was appearance of impropriety, right? But there was like an odor of mendacity, chat. That's what it was. Do y'all remember that? The odor of mendacity was apparent. And what does that mean? Because, I give you guys a little bit of tea, a little bit of legal, and I break it down for the regular people. What that means is that you have actions that show that you yourself are not following the rules that you're trying to say that other people broke, right? So that odor of mendacity was still out in the open, right? It was like all over the news. I think I was watching it all over the place. People were just talking about the odor of mendacity. So that being said, the trial was put on hold. And because she wanted to raise it to the Supreme Court, that brings us to September 16th, 2025, today, when the Supreme Court came out with their decision. All right. We'll start off with Steve Sadow and what he said on Twitter this morning, and then I will read a few super chats, and we'll check out the ruling because I haven't looked at it yet. I have it here, but I haven't read it yet. I wanted to read it with all of y'all. So why don't we go ahead and take a look at the official statement from Steve Sadow. This is Trump's attorney. This morning, Steve says, comment by me as President Trump's lead Georgia defense counsel. This was as of 8:24 this morning, so he probably knew about the ruling before the public did. He said the Georgia Supreme Court has correctly denied review of the Georgia Court of Appeals decision disqualifying DA Willis and her office as prosecutors in the Fulton County RICO case. Willis's misconduct during the investigation and the prosecution of President Trump was egregious, and she deserved nothing less than disqualification. This proper decision should bring an end to the wrongful political lawfare prosecutions or persecutions of the president. So Steve Sadow, again, came out with this statement. Lots of respect for Steve. But again, nobody would know about this affair unless Ashley Merchant wasn't on her neck really, really, really like digging and figuring out what was going on. It's really because of Ashley Merchant. I'm sorry, as a female legal person, I gotta give Ashley her flowers. Do y'all remember Terrence Bradley? Ashley was getting information out of him for months, okay? Terrence was on the stand, and it was sad to watch because him and Nathan were like this. They were law partners, and Terrence was acting like he didn't know what was going on, but what we did see was the text messages, and we read the text messages between Terrence and Ashley Merchant, and he was giving her all the details about what was going on between Nathan and Fani, all the trips they took, like using taxpayer dollars. Lo and behold, we see images of them traveling still. It's crazy. It really is crazy. So tell me why, and we're doing a video on this tonight. I need to film it. I just read through the whole lawsuit last night. Guess who is suing AT&T? Nathan Wade. Nathan Wade is suing AT&T because Ashley Merchant subpoenaed to get his phone records and his call logs. So he's still mad because he has that divorce. He still has a pending divorce with the wife, right? So I was reading the lawsuit last night and he was talking about breach of privacy and all of this stuff. It's like, sir, like you are not getting it popping with Fani behind closed doors. So we're going to talk about that lawsuit a little later, but I just wanted to give you an update on Nathan and what he's doing these days. I can't believe it. And this came out last week. So how fitting that this week we have the latest. Let me come to some super chats and then we will look at the ruling in itself and go from there. Shout out to Miss Brenda. Brenda has been with me for 6 months. Says, hey, AV, sigh. Fani fumbled again. The ball just keeps falling. I mean, light convictions when it comes to the YSL RICO case. And then with this one, now it's going to be reassigned to another prosecution's office, and they might decide to not pursue it. And Trump is still in his first year of his second term. You ain't going to get him. Giuliani might be gone. I don't know if he's going to make it. I mean, that sounds bad. Okay, dear Lord, forgive me for my sins. But Giuliani might not make it. Like all these people, they're a little bit elderly. I mean, I don't know. Shout out to D, pops in with it too, says Fani Rico Willis. I mean, yeah, this is not a good look. This is not a good look at all. So the fact that they said, we're not going to review this again, and they're siding with the Georgia Court of Appeals, and we'll see exactly what the majority says. It was a 4-3 decision. I'll explain all of that to you guys in a second. But thank you so much, D, for the support. Hits me with another 2, says Georgia, like, what you talking about, Willis? I mean, yeah. What are you talking about? You know, lots of stuff are, they're coming out, being revealed from the Young Thug trial. Thug had spoken out on an interview recently. And although I did not show you guys that interview, we did a stream and we talked about it. And we talked about the plea deals and some of the things that he was saying that was true, and some of them that were kind of like, because we watched it. We watched the trial. If you've been rocking with me for a while, you probably watched that trial with me from beginning to today. So interesting stuff. Vegeta, you've been with me for 13 months? Wow. We just had an anniversary. Says, wasn't expecting the stream like this stream. Yes, you guys hit the like button. I have not streamed in like 8 days. So whenever that happens, the algorithm resets and then it starts back at 0 and you have to build it back up again. But that's okay. We've been really busy with Vid Summit. I've been getting my workshop ready, doing the website over. I'll show you guys the new enhancements. So it needed to be done. I just need to take some time to work on that. And then we're getting some programs ready for creators that want to learn, so I had to take some time last week to really focus on that. But we are back full time this week with all the tea, all the legal news. But thank you so much, Lord Vegeta. Senator with the 5 says, AV, Fani out here living wild and reckless and mad she got outed, especially the way that it did. Did you open it yet? Senator, here's what Senator's talking about. Because I've had time lately, I actually went and got it. Senator makes candles, y'all. At first, I didn't know what this was. I was like, is it a heart? It is a heart. But they do amazing glassware. And I think this is called Sangre de Vida, right? They do like really cool glassware where some of these are in the shape of skulls, like really cool stuff. And then I think these are handmade. They're really dope. So I did pick it up. Y'all check out Senator. If you check out his website as well, you'll be able to pick up these candles. And Senator, if you post it in the chat, I will try to pin it for anybody that is interested. So I like highlighting, my community when y'all do really cool stuff, like if you're a candle maker, you have your own independent business, stuff like that. We really try to help out because this is cool. I was like, I'm going to light it up for the stream, but this is dope. So, and it looks like they're like bottles. Very, very cool. I mean, I don't think I've ever seen a candle made like that. So kudos to you. But thank you so much, Senator. D hits me with another two, says Terrence Snitch Bradley. Y'all remember that. That was interesting. Drew Beats been with me for a year, says, okay, I've been a member longer than this, but it's been 12 months since I've been giving you cash. Nathan Wade, LOL, they're still together too. Yes, y'all remember that? They were talking about keeping cash, large amounts of cash in the house, and like how Fani would pay for things in cash. Like she would just walk around with like 2 racks of cash. I'm like, who are you? The cash was a big thing. It was a big thing. Yeah, you guys have been rocking with me for a while if you're up to speed on this particular legal matter. All right. So that's the background. We know what happened. The case is put on hold. It is now with the Georgia Supreme Court that just came out with this ruling here. So let's take a look at the ruling. Here it is. This came out this morning, September 16th. And quick note on the Supreme Court in Georgia, it's a panel of judges, the same way that the Court of Appeals is a panel. It's like, I talked to you guys about that triangle. The bottom portion is the trial court. The next step up is the Court of Appeals. And then the top level of that pyramid is the Supreme Court. Other than that, like once you get to the top and you still want to keep going, you would go to the Supreme Court of the United States. That's how that pyramid works when you want to appeal a decision or to appeal a verdict, whatever the case may be. That's how it works in this country. Now, so she has made it to the top of her state and they said no. Let's see why. All right. So the Honorable Supreme Court of Georgia, and you could see all of those defendants that I mentioned. It looks like they narrowed it down to about 9 that fought this as a group. So you have Roman, Schaefer, Chile, Meadows, Trump, Latham, Giuliani, Clark, and Floyd. So 9 defendants here. It says the Supreme Court today denied the petition for cert in these cases. So they're not even going to hear it. And this was the Supreme Court of the state of Georgia, the clerk's office in Atlanta, and the clerk signed it this morning. Okay, now when it comes to decisions and how they are written, it's really broken down into 2 categories, right? Once they vote 4-3, 4 of them voted that they didn't even want to hear this joint. They were like, no, we're sorry, Fani, no. 4 of them did not want to hear the case. 3 of them dissented with that decision, and then they are allowed to write why, right? We'll probably look at one of them because when it comes to case law, you guys see those books behind me. What will happen is you'll have a majority view where one judge will write for the group that won, the majority, and then you'll have the dissenters, they'll write their own opinions after. They can get a little dry, so we'll read like one of them. But let's see what the judge in this decision said for the group of 4 that did not want to hear it. It looks like Pinson is the one that wrote this, and he is concurring. So that means he agrees in the denial to hear Fani's case. He says, I agree with the court's decision to deny these petitions for cert. Here's why. 1, this court's power to review cases that the Court of Appeals has already reviewed, what we call review by cert, is set by our state constitution. The Georgia Constitution grants our court the authority to review by cert only if cases in the Court of Appeals are of gravity or great public importance, right? That's what their Constitution says. This means that we generally do not grant cert review just because the Court of Appeals or the trial court might have gotten something wrong. That is for mere error correction. That's interesting. Nor do we typically grant review just because a case or a subject matter happens to have found its way into the public spotlight. Instead, our focus is assessing whether a case warrants the exercise of cert jurisdiction is supposed to be its potential impact on the law in Georgia. To gauge that impact, we ask whether the case presents a legal question of gravity or great importance to the public. Um, we typically assess whether a given question has sufficient gravity by asking, for example, whether the Court of Appeals has decided the question in a way that conflicts with the other decisions of the Court of Appeals of this court, answered a legal question by applying precedent of this court that should be reconsidered, or decided an important question of state law that is likely to recur and has not been, but should be settled by this court. These non-exclusive examples reflect the aim of cert review, ensuring that our court's interpretation of the law in Georgia is correct, settled, and ultimately uniform with respect to important legal issues that courts and litigants are likely to see in the future. But identifying a legal question for sufficient gravity is not enough on its own to warrant cert review. That question must also be presented by the case when it arrives at this court. Although our Constitution entrusts this court with the responsibility to settle important legal questions, we're still a court. And courts are not vehicles for engaging in merely academic debates or deciding purely theoretical questions. Instead, we say what the law is only as needed to resolve an actual controversy. Thus, even if a party has identified a question of gravity in this case before granted review, we must still ask whether answering that question of gravity is necessary in some way to resolve the case. If not, for example, if answering that question wouldn't matter to the outcome of the underlying case, or if that question was even squarely presented or decided in the courts below, then reaching out to decide that question anyway would exceed our limited judicial role. In other words, before granting cert review, we must ensure not only that the petition identifies a question of gravity, but also that the question is actually presented by the case, and that answering it would help resolve the case. So what this is telling me is they don't think that Fani Willis had a sufficient legal question to grant review. That's it. Like, what is your question? You didn't like the outcome of it? What is the legal question that we need to resolve on the Supreme Court level? We don't see that here. So if that's starting with this, then that shows that her appeal didn't have a lot of legs, maybe no legs. It says here, the state asked us to grant review to answer the question whether a prosecutor may be disqualified based solely upon the appearance of impropriety and absent a finding of an actual conflict of interest or forensic misconduct. She's interesting. So solely on appearance of impropriety and absence of an actual conflict of interest or forensic misconduct. So Fani was basically saying, all right, there's an appearance of impropriety. It looks inappropriate. But what have I done that proves that there's forensic misconduct or a conflict of interest? This is hilarious. It really is funny. In an appropriate case, that question might warrant our review. The legal basis for a rule that prosecutors may be subject to disqualification based only on conduct that creates the impropriety or appearance of that is not clear. I'm not aware of a specific constitutional or statutory basis for such a rule. This court only suggested that basis for disqualification as a possibility for attorneys generally. In the Bloomingfield, there's a case that they used, and that decision relied in part on a since scuttled rule of professional responsibility addressing the appearance of impropriety. I'm going to skip that whole case law there. On the other hand, the idea that public prosecutors should be held at a higher standard than private attorneys for purposes of disqualification is not without force, and it finds some support in the language of some of our earlier decisions. I agree with that. They should be held at a higher standard, prosecutors, right, than regular attorneys. I just put a poll up for y'all too to see what you think so far about this decision. They're citing a few cases here, so I'm going to skip all that. If this question, whether conduct creating an appearance of impropriety alone is grounds for disqualifying a prosecutor, is presented in future cases, we may well need to take it up on one of them. But in my view, that possibility That possibly cert-worthy question is not presented by this case, at least not as it appears from this court. The root of the problem is the state's approach to litigating this issue on appeal. Oh, okay. They're saying that Fani's trying to fight this on appeal instead of fighting it in trial court. Wow. Okay. In the Court of Appeals, the defendants here appealed the trial court's disqualification order, which one found that the conduct of the district attorney and special prosecutor Nathan Wade created a significant appearance of impropriety. And two, as a remedy, determined that one of those two prosecutors would have to withdraw from the case. So if y'all remember, they gave Scott McAfee, who is the presiding judge over the hearing, he made an order and he's just like, okay, y'all both can't be here. So either Nathan is off of the case or the entire office is off of the case. Fani fired Nathan, AKA he put in his resignation, all right? So he got kicked off. Then they're like, okay, the defense team is like, all right, you're taking him off. If that's the case, let's take it a step further. So, since judge, you're saying that there's an appearance of impropriety, we want both of them off. Let's get Fani off too. Get Fani off of the stand. She's admitted to these things. And if you guys are saying that there is an appearance of impropriety, why is the Fulton County DA's office still on the case? Take them off too. So they really pushed for that to happen. Now, the Court of Appeals agreed. They said, yeah, take her off too. Fani disagreed. And that's where we are here. All right, that's where we are right here. Alfred's asking, what's the makeup of the Georgia Supreme Court? It's 7 of them. I have a picture. I'll pull it up on their website. We can see what they look like. But they do keep it up there. As a remedy, they determined that 2 of these prosecutors would have to withdraw from the case. In doing so, the defendants did not contest the appearance of impropriety finding, but they contended that the trial court's one of you has to go version of disqualification was error, and that it should have instead simply disqualified Fani, the district attorney. And critically, the state did not cross appeal the trial court's ruling. Okay, that's a technicality. So the 9 defendants, they were like, all right, Judge McAfee, you said that one of the 2 has to go. Nathan goes or Fani goes. It should be both, right? It should be both. They think that it's more harmful if Fani stays than if Nathan stays. They should, like Scott McAfee should have just took her off then, but he didn't. He didn't, and that's why they appealed. So taken together, the parties' position in the Court of Appeals posed a narrow and case-specific question for the Court of Appeals to answer, taking as an unchallenged given both the trial court's finding of a significant appearance of impropriety and that some type of a disqualification remedy was required to cure the harm caused by the prosecutors, both of them, their conduct. Was the trial court's chosen remedy an abuse of discretion? And indeed, that was how the parties argued the issue at the Court of Appeals. And more importantly, the Court of Appeals legal analysis appears to have stayed within that narrow framing. In its opinion, the court explained that because the state failed to cross appeal, our consideration of the appearance of impropriety is limited to the remedy fashioned by the trial court. The court went on to say that it had to address the remedy in the context of a significant appearance of impropriety caused by the conduct of a public prosecutor, which distinguished this case from private counsel disqualification cases. And the court framed its key holding as one about the choice of remedy too, concluding that the trial court erred by not disqualifying the district attorney because the remedy crafted by the trial court to prevent an ongoing appearance of impropriety did not fully cure the harm. And no other remedy will suffice to restore public confidence in the integrity of these proceedings. In short, rather than deciding any broader question about whether an appearance of impropriety can serve as an independent ground for disqualification of public prosecutors, the Court of Appeals decision appears to have resolved a narrow case-specific dispute about the trial court's choice of disqualification. If that's the best reading, the Court of Appeals decision, if that's the best reading of the Court of Appeals decision, and I think it is, that decision does not raise a question of gravity that warrants our further review. Damn. They're like, listen, the Georgia Court of Appeals already solved it. Nathan's gone. Now, Fani, you're gone too. You can't, like, you're off. Get off the case. Give it to another prosecutor's office. But again, here we are. And he's just like, okay, they made the right decision. If the question is, okay, does Scott McAfee make the best decision on not both, but either or? One has to go. This one goes or the other goes, and one of y'all could stay. They appealed it. The defense attorneys appealed it because they're like, no, both of them need to go. If he worked for that office, then it's tainted. And if they had a relationship, are they disinterested parties? Who else did they investigate? All of that. All of those things. And then we're already on thin ice with Fani because, she won that, she got reelected last year. I didn't vote for her. But, I think she won by 100,000 votes. So really it's just the contender didn't have the best campaign, So we'll see what happens with all of this. But now Fani is no longer allowed to be on this case, and it is going to be reassigned to another prosecution office. The question whether a trial court abuses its discretion in choosing a particular disqualification remedy under the specific and unusual circumstances of this case is not a question of Georgia law at all likely to arise in future cases, nor does the Court of Appeals fact-bound decision that the trial court abuses its discretion create any apparent conflict with decisions of the Court of Appeals of this court. Thus, even if one believes that the Court of Appeals erred in reaching that decision, granting review to answer that question would be mere error correction. And this court generally does not exercise our cert jurisdiction merely to correct errors that do not have some broader impact on Georgia law. To be sure, it's plausible to read the Court of Appeals decision as holding more broadly that, as a general matter, conduct that creates an appearance of impropriety can be grounds for disqualifying a prosecutor. At bottom, the Court of Appeals concluded that the district attorney had to be disqualified to address the appearance of impropriety found by the trial court, explaining that this is a rare case in which disqualification is mandated. Goddamn. One might argue that such a decision rests on necessary promise that conduct creating an appearance of impropriety as a sufficient ground for disqualification, in turn, treat that promise as a holding. Okay. I disagree with the view in light that the posture of this case as it was presented to the Court of Appeals and the court's express and repeated focus on the choice of remedy alone. But I acknowledge that drawing the line between the holding and dicta is not always easy, and one judge's holding might be another's dicta. Even under that alternative reading of the Court of Appeals decision, however, I am not persuaded that this case would warrant our review at this time. For one thing, as discussed above, it is not so clear that there is no conceivable legal basis for holding a public prosecutor to a higher standard than a private lawyer for purposes of disqualification, at least as a general matter. Blah, 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 lots of case law. For another, even assuming the Court of Appeals held as much, such a public prosecutor-specific holding would not appear to conflict, at least not squarely, with any decisions of our appellate courts. But perhaps most important, it is not clear, at least at this time, that this legal question will reoccur with any frequency. Oh, that's a good point. Are you going to have other prosecutors in the future that get it popping, want to throw RICO everywhere, looking for RICO? Looking for RICO and Young Thug, looking for RICO with the president. I don't know. It's very interesting. Will they see this again? That's why they're like, why do we need to rule on this? Appellate decisions addressing attempts to disqualify prosecutors are few and far between, and only a handful of those address the claim that a prosecutor must be disqualified based even in part on conduct that created an appearance of impropriety. Could this case change that? Perhaps, but it seems more likely to me that the circumstances of this case are unique, and I'm not convinced that parties will rely on it for anything broader than the Court of Appeals' stated conclusion that, based on the specific findings in this case, the trial court chose the wrong remedy. And of course, if this prediction turns out to be wrong, we'll have the opportunity to address the legal question about the appearance of impropriety standard for public prosecutors when it's properly presented in a case without the unusual procedural limitations and other circumstances that make this case a poor vehicle for reaching out that question. Damn, Fani, your case is a poor vehicle for reaching that question. Members of the public may well be interested in the case underlying this petition for cert, but our focus in assessing whether to grant review under our cert jurisdiction is on the law in Georgia. Given the parties' positions, the corresponding narrow question before the Court of Appeals, and that court's limited resolution of that question, the decision below does not raise the kind of legal questions that warrant further review by this court under our cert jurisdiction. I am authorized to state that the presiding judge, Justice Warren, and Justice Bethel join this concurrence. Ooh-wee, what do y'all think? What do you guys think? They're like, all right, Fani, listen. No. No. I mean, I know you want it back, but you can't have it back. It's going to go to someone else. And here's what's likely going to happen, chat. The case is probably going to get dropped. It's either that, or if they give it to another neighboring county, Cobb County, DeKalb, another county in Georgia, are they going to have, number one, the resources to look into this, right? Fulton County is one of the bigger counties. And Fani has told us about the limited resources that she's had at her office. And, contrary to also paying Nathan Wade $700,000 to cover this case, while the other prosecutors were making like $150 a year. It was so crazy. You gave him more money. So you're going to need the resources to prosecute this case. But at the same time, you're going to have to wait Trump out. We're almost at the end of year one of the second term. He's got 3 more years left. So it's going to be tough. It's going to be very tough. Let me just make sure I'm all caught up on super chats here. Let's read one of the dissents. I'm not going to read all of them because there's a few people that disagreed with this decision. Let's go to one of the judges that disagreed and let's see why. So let's go to Justice McMillan, who dissents. This one says, I would grant cert because the legal issue necessarily presented here, whether an attorney can be disqualified based on the appearance of impropriety alone, affects every single active lawyer in the state of Georgia. The Court of Appeals decisions are in conflict at this point. Our court's precedent warrants reconsideration, and the issue is likely to recur. How? So this judge thinks that this issue is likely to occur again if you have 2 people that are working in one office that are intimately involved. I mean, maybe. What do y'all think? I don't know. I don't know if it's likely to reoccur in the same set of facts. It says some background is required to understand the gravity of this issue. In 2023, the state, through the Atlanta Judicial Circuit District Attorney Fani Willis, charged respondents in the 97-page indictment with RICO violations and other crimes in connection with the alleged conspiracy to unlawfully change the outcome of the 2020 presidential election. Respondent Roman moved to dismiss the indictment and disqualify Fani, her office, and Nathan Wade from further prosecution based on alleged conflict of interest and an appearance of impropriety, asserting that Fani and Nathan were engaged in a romantic relationship and that Fani had a personal financial interest in the case. The other respondents later filed motions to dismiss and for disqualification on the same grounds. Okay, that paragraph is taken from those proceedings. In addition, the trial court noted that the odor of mendacity remained with respect to the testimony of certain witnesses, and that reasonable questions about whether the DA and her hand-selected SDA or SADA is Nathan, testified untruthfully about the timing of their relationship. And that further underpins the finding of an appearance of impropriety, and they need to make proportional efforts to cure it. As a remedy for the financial cloud of impropriety and potential untruthfulness, the court provided two options. Fani and her office step aside, or Nathan withdraw from the prosecution team. The trial court also denied the respondent's motion to dismiss the indictment. The respondents appealed. On appeal, the Court of Appeals affirmed in part and reversed in part in a divided opinion, relying on a leading case from this court. The majority opinion explained in Blumenfeld, this court held that a trial court's disqualification based on the appearance of impropriety due to status was improper, and that the appearance of impropriety based on conduct was also generally insufficient to justify disqualification. But this court left open the possibility that the appearance of impropriety based on conduct would justify disqualification when the interest of public at large outweighs the client's interest in choice of counsel. The majority opinion explained that the DA's important role of the administration of justice justified disqualification because there was no countervailing interest in choice of counsel. Relying on this reasoning, that the majority opinion concluded that this is a rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence in the integrity of these proceedings. Okay, what is this person's point? On cert, the parties focused their arguments on whether the Court of Appeals erred in the remedy that it ordered based on the appearance of impropriety by DA Willis, assuming, as did the lower courts, that Blumenfeld, its progeny, and other case law relying upon the appearance of impropriety factor in the context of attorney disqualification remained good law. All right, here it goes. Land the plane. I question that assumption, which is the linchpin of the Court of Appeals decision and therefore part of its holding. Okay. Blumenfeld relied on Canon 9 of a Code of Professional Responsibility, which provided a lawyer shall avoid even the appearance of professional impropriety. However, effective January 2002, that's an old case, this court revised Georgia's rules of professional conduct, removing Canon 9. Oh, and any mention of appearance of impropriety outside a comment to the rule concerning a lawyer's direct dealings with a tribunal. Okay, so what this judge is basically saying, and they're very long-winded here. I'm just going to scroll ahead. Very, very long-winded. They're looking at a technicality as well, as far as a rule from 2002 and that rule being removed from the model rules of ethics in their state. Damn, this is super long-winded. They go on for an additional 10 pages, basically saying that the rule or the case that they used for this in the Court of Appeals, that case that they used relied on that rule that was removed in 2002 about the appearance of impropriety. So that's why it's wrong. Maybe that's why y'all lost. I'm just saying. I mean, maybe that's why. It doesn't seem like a strong argument at all. And so, let me see what y'all are saying in the chat. Shout out to Michelle. She says the intimacy wasn't the sole issue of his lack of qualifications. Yes. So thank you for saying that, Michelle. His lack of qualifications, Nathan Wade was a judge, but he was like a judge that presided over like traffic tickets and civil things, right? Nothing as serious as criminal law. Nothing as serious that would qualify for him to come after a sitting now sitting president, but a former president back in the day. Did he have experience with election law? No. Things that would qualify him in this case, white collar crime, even, things like that would be good, but we didn't see that. Lack of work product for that amount of money, in my opinion, are the issue. I mean, yeah, $700,000. And it's the state of Georgia paying him that amount. Although it gets paid to his law firm, he was paid that amount. And this is also coming from the same DA that is like, we have a lack of resources in my office. We need more money. It's just a lot. It really is. K. Joseph says, yes, public confidence for real at Fulton County is at an all-time low. I mean, it's not good. It is not good at all. Michelle says, are the other counties required to accept the case? Required? No. I mean, they can decide whether to try it, but it is going to be assigned to another county. And I don't know what system that they use when they were trying to reassign. I don't know if you guys remember the YSL trial. When Judge Glanville was removed, they used a random system to identify the next judge that was going to take over the case. At first, it was Judge Ingram, and Judge Ingram, also in the same courthouse, had a conflict of interest, so she was not able to take on the case, and that is how we ended up with Judge Whitaker. So Tom says the goose is back on the loose. Watch out, Atlanta. Yeah, she's back out there. She is back out there. So Fani Willis is going to be continuing to take other cases, but this one has now been removed officially from Fulton County DA's office. Joe Blow says Georgia is so tired of Fani Willis and her crap. I think people are. They really are. And we'll see if other counties are going to televise what happens next, if they're just going to dismiss it. But again, you have to wait out until Trump is done with his presidency, and that's going to take a little bit. That is going to take a little bit. Shout out to Jensky, says, I've been on AV Fam's list since YSL days. Yeah, there's a few cases coming, y'all. I wanted to pop on here because this is fresh news for today. Nathan's, wait till you guys see that lawsuit, but I'm not going to read it to you because that one is like 100 pages. So I'm just going to cut out and get to the good parts. Share that. ASAP Relly is back, man. ASAP Relly, and if you guys don't know who I'm talking about, ASAP Rocky and ASAP Relly had a contentious criminal trial at the start of the year. ASAP Rocky was facing jail time for pointing a prop gun and discharging a prop gun at a former friend. Now, that case is done. That's the criminal side. But what we are going to see is the civil side of that trial. Now, Relly's attorneys are backing out of it. So he's scrambling. Like they gave him a deadline to find new lawyers, and he's having a hard time. So we'll see if that one even makes it. But that's another one that's coming. You guys heard about YNW Bortland and that whole thing with YNW Melly. So that's the other news. Tory Lanez wasn't in court yesterday, but there's that Milagros case with Megan Thee Stallion, and they're trying to depose Tory Lanez, and Tory said, no, I'm not doing it. So we have that as well. And then, of course, Lil Nas X was in court. I'll bring y'all up to speed on that one. I am going to start to wrap up and get out of here, but shout out to Senator again. Says, so does this remove Fani and her team from office totally, or just from this case? Just from this case. So Fani and team are still in seat. They're still working. I think I saw 88 Love and Another Matter like a week or two ago. Recently, same thing. Simone Hilton was fighting another case. So all of those guys are still going to be in office. They still have their jobs, but they are removed from this case. So I hope that settles it. But yeah, chat. So we're just waiting. There's Lil Nas X. I think his court date is in November, October. I have a few on my radar. We have that Courtney Clenny case, is that OnlyFans model that threw a knife at her boyfriend. Like, she's a white woman, he's a black man. That has been pending for like 2 years. So I'm waiting for that to happen. But as of right now, her court date is in December. So a little quiet for a little bit, but it ain't gonna be quiet for long. We had a really good time with the Cardi B case recently. Like that was hilarious. So really, really looking forward to the new stuff we have coming on. D says, did Nate did raise the rate for gigolos in Georgia. Yep, sure did. Sure did. But yeah. All right, chat. I am going to pop on out of here. If you're watching this on replay, let me know what you think about the Nathan Wade, Fani Willis saga. I did put a poll in the chat to ask you guys that are here right now, did the Georgia Supreme Court make the right decision? 93% of you guys say yes, that they did. They made the right decision by taking this case away from Fani and putting it somewhere else. She's notorious for bringing RICO charges against groups of people. And this is also going to set the precedent on what happens moving forward. If there is an appearance of impropriety in this state, elected officials have a high standard, right? The public, the way they look at you, it all matters. If you're creeping, right, and you get caught and the world sees it, do you think that they're going to want to keep these people in positions of power? Especially, I really felt bad for Joycelyn Wade, to see her, because their divorce is still not finalized. To see him admit to all of this is crazy work. It's crazy work. All right. Well, I'm going to get out of here, chat. Please like, hype, subscribe. Let me know what you think in the comment section below. We read everything. Make sure your notifications are on because we got a lot of short videos in process. So we'll see you in the next one. Stay safe out there. Bye.